Tired of compliance headaches? Worried about refund claims, conformity disputes, or withdrawal-right traps? The EU Consumer Rights Directive turns those risks into manageable obligations, giving your business a clear roadmap for transparency, update duties, and digital contract compliance. First, a disclaimer. This article is for informational purposes only and does not constitute legal advice. If you would like personalized guidance, you can contact our team or other qualified professionals. Hey everyone, Robert here, legal consultant, licensed tax advisor, and founder of Kiroptera Consulting. We've helped countless SaaS and digital businesses stay compliant while keeping customers happy. Today, we're diving into the Consumer Rights Directive, CRD for short, and what it actually means in practice for app providers, SaaS platforms, and streaming services operating in the EU. Offering an app that users download, a subscription that streams content, a SaaS platform users access in browser, then the CRD and its partner, the Digital Content Directive, govern your B2C contracts. They define digital content as data supplied digitally like apps, games, music, videos, or an ebook, whether downloaded, streamed, or supplied on a tangible medium like a USB drive or disk. The goal? High consumer protection that boosts fair cross-border trade. Your obligation? Know which directive applies to you and comply with it. Let's start with the scope, because getting this wrong is a costly mistake. If your digital product is supplied on a tangible medium that serves exclusively as a carrier, like a disk or USB stick containing only the software, it still falls under Directive 2019/770 on digital content and digital services, not the sale of goods rules. Directive 2019/771 on the sale of goods applies instead to goods with digital elements. Think a smart TV or a connected appliance. If your product is intangible, downloaded, streamed, or accessed via SaaS, Directive 2019/770 applies as well. These are different regimes with different conformity and remedy rules. Know which applies to your product before drafting a single line of your terms. So, what does conformity mean for your business? Your digital product must, firstly, match its description and possess the functionality and quality you promised. Secondly, remain compatible with the hardware and software you specified at the point of sale. And lastly, receive all necessary updates, including security patches, for the entire duration of the contract. Under Article 8, Paragraph 6 of Directive 2019/770, you must also supply the most recent version available at the time of contract conclusion, unless the consumer explicitly agrees to receive an older version. And on updates, you must actively inform the consumer about available updates. If a consumer fails to install an update you properly notified them about, and a defect results solely from that failure, you're generally not responsible for that specific non-conformity. Get your update notification workflow right. It protects you legally. Here are some practical compliance steps for traders who offer digital products. Firstly, map every digital product's functionality, compatibility requirements, and update obligations before launch. Secondly, specify in your terms which version is being supplied and your update delivery mechanism. And lastly, document your update notifications to consumers. These records are your legal shield. This keeps you compliant whether you offer a one-time game download or a monthly streaming subscription. Next up, pre-contract information obligations, the transparency rule that prevents disputes before they start. Before the consumer clicks buy or subscribe, You must clearly disclose the functionality of the digital product, so how the product works, including any data tracking, digital rights management, DRM, or usage restrictions. You must also disclose the compatibility, like which operating systems, hardware, and software versions your product supports. And lastly, you must disclose interoperability, meaning how your product interacts with third-party hardware or software, where you're aware of it. So, why does this matter commercially? Under Article 5 and Article 6 of the CRD, and for conformity disputes, specifically Article 12 of Directive 2019/770, failure to provide mandatory pre-contract information means the burden of proof shifts in your direction. You need to demonstrate the product met its description. It also potentially invalidates the consumer's consent to waive the withdrawal right for digital content. More on that later. Missing this information is not just a compliance gap, it is a litigation risk. Here's a quick compliance checklist for your sales page and onboarding. Firstly, list technical requirements, DRM restrictions and tracking features visible on the product page. Secondly, publish your update and modification policy before purchase. And lastly, keep timestamped records of the pre-contract information displayed to each customer. These simple steps add significant legal protection for your business. Now, let's talk about the cooling off period, and this is where app stores, SaaS platforms, and streaming services most frequently get into trouble. Under Article 9 of the CRD, consumers have 14 calendar days to withdraw from any distance or off-premises contract without giving any reason. For digital content not supplied on a tangible medium, the right to withdraw can be extinguished before those 14 days expire, but only if the following conditions are met. Firstly, you have obtained the consumer's prior explicit consent to begin performance before the withdrawal period expires. Secondly, the consumer has acknowledged that they thereby lose their right of withdrawal. And lastly, you should confirm that acknowledgement to the consumer on a durable medium such as by email. If you fail to meet those conditions, the withdrawal right survives. And if you forget to inform the consumer about the withdrawal right at all, under Article 10 of the CRD, the period is extended by 12 months. Once a consumer validly withdraws, you must issue a full refund within 14 days. Here are some operational steps to protect your business. First, build a compliant consent and acknowledgement flow into your checkout or onboarding. This cannot be buried in terms and conditions. Second, deliver the acknowledgement confirmation to the consumer on a durable medium, for example over email. And last but not least, automate your refund process to meet the 14-day deadline. This balance lets you deliver instant digital access while remaining legally protected. Finally, how the CRD fits into your broader compliance architecture and what it does not cover, so you do not confuse your obligations. The CRD and Directive 2019/770 govern contract law, information duties, withdrawal rights, conformity, and remedies. The GDPR governs personal data processing. They are separate legal frameworks, both mandatory, and compliance with one does not substitute for the other. Your privacy policy and your contract terms serve different legal functions. Maintain them separately and accurately. Under Directive 2019/770, your consumers are also entitled to notifications before any service modification that goes beyond what is strictly necessary to maintain conformity. They are also entitled to a right to terminate the contract if a modification materially and adversely affects their access to or use of the digital content, unless you offer them the right to retain the unmodified version at no extra cost. And finally, they are also entitled to remedies for non-conformity. Firstly, they can request a repair or replacement. If those fail, a price reduction or contract termination can be requested. So, if you are a SaaS or streaming provider, here is a key compliance architecture you can adjust and adopt. Firstly, separate your contractual obligations from your data processing obligations in internal compliance documentation. Secondly, build modification and termination notification workflows into your platform roadmap. Thirdly, establish a clear non-conformity remedy process. First, repair update, then replacement, then financial remedies. And lastly, note that AI-specific obligations for your services come from the EU AI Act and the Developing AI Liability Framework, not the CRD. Providers who correctly implement all frameworks reduce dispute rates and build durable customer trust. Quick recap for providers. Know whether Directive 2019/770 or 2019/771 applies to your product. Remember, digital content on a tangible medium still falls under 2019/770, while 2019/771 covers products with digital elements. Disclose functionality, compatibility, and DRM upfront on the sales page, not buried in the terms. Build a compliant withdrawal consent flow for digital content. Deliver updates and notify consumers correctly. Your notification records protect you from liability. And keep your CRD contractual obligations strictly separate from your GDPR data processing documentation. Get this right and digital borders become opportunities, not risks. If this helped you understand your obligations as a digital provider, hit like, share it, and subscribe for more compliance insights. Explore our Knowledge Center for full resources. Links below. Thanks for watching, and remember, compliance with the law prevents the flaw. Till next time.